There are two parts to the social-legal study. One was looking at the patterns and understanding what's happening, how to understand the practice of witch hunting. And this is the section on law, how law relates to it. There are two parts to this. We looked, of course, at the state laws that are in place in all the three states, but we also looked at all the judgments that were available on the issue and police records. This piece on the law becomes very important because for a long time there has been a very strong demand for special laws on witch hunting. And in the last 3 years, actually laws have begun to be enacted quite rapidly. 3 laws have come into being: Maharashtra, Orissa and Rajasthan, and Assam has also now enacted a law. So I think this helps us evaluate the purpose of a special law in responding to witch hunting. Now, if we look at the data that we had before us in relation to just the law part, we are looking at a sample of 144 cases. The FIRs were 85, and we have the breakup. We can see that the maximum cases came from Bilaspur in Chhattisgarh. And then Jharkhand, we actually had to cover 2 districts because we were getting no cases from it. And later we'll see that as far as the judgments are concerned, we had the highest cases from Jharkhand. The case law we looked at, which is just the reported appeal court judgments, we looked from pre-1947 to 2012. There were 59 in all. They were from 10 states, covering 10 states, with a maximum number from Jharkhand, followed by Bihar. If you look at NCRB to do any analysis, there is no coherent category of witch hunting because the motive of witchcraft under that category, child sacrifice cases are also put in. And now if we look at the total number of victims, we have 168 because there's more than one victim per case. And these are drawn from 85 FIRs and 59 appellate level judgments. They include 2 types of victims. One is the primary victim, the person who is labeled as a witch. And the secondary victims are those who are collaterally harmed because they're trying to defend and they are standing with the primary victim. Most of them are family members. We have the ratio here. You can see that there are some male victims, but it is primarily females who are victimized. And I think for us, this part of the legal study where we're looking at the profile of the victims, we only did that to see to what extent this completely independent source of data was corroborating our findings from the case studies, which is what Anuja presented. And if we look at the overview of victims, we find in terms of the primary victims, it's 121 women compared to 23 males. The age group is 40 to 60. And predominantly the victims were married. Only in exceptional cases were they never married or widowed. As far as the secondary victims go, the larger number is of men. There are 19 and there are 4 female. You see, this is not a realistic number of secondary victims because in the FIRs and in judgments, only those secondary victims will find mention if they also suffer serious bodily harm, if a crime is committed against them. Otherwise, they're not. So in our case studies, we encountered many more secondary victims. Now, in terms of the motives, at least 53 cases showed some kind of illness, existence of illness, whether it was death of cattle or family members or a person. And the other big number was in relation to property and family disputes. We see the bigger chunk has to do with the lack of healthcare in the areas we are talking about, which of course gets compounded with low levels or absolutely no formal education. And under motives, another interesting factor which throws light is that the relationship of the primary victim with the accused from 85 FIRs, we saw that 46, which is quite a large number, were related to the accused or were probably related because they shared the same names. So where the relationship is made explicit in the FIRs, they were from the husband's side. So to that extent, again, this very different source of evidence is corroborating the findings from the field. Now we are going to go to the legal part of the findings. What does it say about the law? Should we be asking for law? Now we are looking at the special law. All 3 states have it. One had it in 1999, Bihar 2001 in Jharkhand, and 2005 in Chhattisgarh. Now we see the total number of FIRs are 85, but FIRs which are solely under special laws are 6. Special laws only have very few provisions. They are only particular to witch hunting. And the purpose of special laws is to nip the problem in its bud, because at the point of labeling, at the point of jhadphook, at the point of harassment, the special law can be invoked. The provisions are barely 6 or 7 in all. Our understanding is they are designed to eliminate discretion by the police, because you have a law, you have to act, and the provisions, although they attract a very small punishment of 3 months or so in the Jharkhand and Bihar, they are cognizable and non-bailable, as is the Chhattisgarh law. So in fact, they compel the police to act, but we see only in 6 out of 85 cases are they exclusively under special law. The rest of the cases are all under Indian Penal Code. And in 73 of them, special law is just tagged along to show the motive for murder, the motive for this, the motive for that. Not of any significant purpose. In the case law, when we look at the judgments, we see that all the case law relates to killing. There are about 2 which are attempt to murder, all of them are murder. The number of states from which where special laws exist, we got 42 judgments from them, but all these judgments precede the enactment of special laws. There were only 5 judgments which relate to offences that were committed after the special laws were enacted. In these 5, only 3 have a mention of special law, and in that pie diagram, the red is IPC. The green is IPC alone. Now, what does it tell us about the functioning of the criminal justice system when we want the state to do something about it? Well, this is a reality we must be informed about before we demand anything of the state. The police, we found, only acts when there's a high threshold of violence, typically by a mob in a public place. Only then is an FIR filed. Special laws are therefore become redundant, where somebody has abused somebody and so on. And of course, there are impracticalities of what abuse can we invoke the law on. Now we see, in terms of the most frequent provision under the FIR, 79 of 85, provision 323, which relates to voluntarily causing hurt. It has a sentence of 1 year, it is bailable, and it is non-cognizable. It is literally ek do thappad marna. It's that level of marpeet. Simple hurt it's called. 506 criminal intimidation, 294 obscene acts and songs. Then we have breach of peace, wrongful restraint, trespass, and we have 16 cases of murder in our FIRs, which are 85 and all. Now we look at exactly why the police, for what kinds of crimes are they invoking simple hurt, which is section 323, maximum of 1 year sentence or fine. Now all these things are not in one case, but they are from different cases, and often many of these things happen together. Beating, disrobing, inserting twig in the ear, forcible consumption of dirty water from old leather shoe, forcible consumption of feces or urine, forcible tonsuring, parading cow dung and feces on the face, force to lick spit from the ground, public stoning, pulling hair and setting on fire. These is what qualifies as simple hurt. So this is the discretion of the police that we hope to rely on for future remedies. Now, also more about the police, we see that only after 2013 does disrobing get covered. Otherwise, disrobing a woman and parading her naked was 323, which is simple hurt. And these are state patterns. Jharkhand, we got 9. The story actually is we got 2 cases from 2010. 2011, there was nil cases. And 2012, the activists asked senior people in the police, what is happening? There are so many cases, but nothing is being reported. And then a couple of more cases were created. And we found 5 of them were compromised after charge sheet. In Chhattisgarh, 51 cases where a section 294 gets applied, which is from the IPC, not from the Chhattisgarh law, which is actually a much better law and gives up to 3 years sentence. But we got 294 applied, which is public nuisance created by obscene songs and acts. then the police, of course, has the discretion to use what they want to use, and that is punishable with a 3-month sentence. Now we look again at the criminal justice system, this time at the investigation and the prosecuting agency. We can only get this information from the case law, from the judgments. We didn't have access to trial court records. Now we see all 59 cases involve appeal against conviction of the accused for murder. Not a single case of appeal by the state against acquittal. So it's all the accused who are coming to the higher courts. 22 of the 59 cases get overturned, and 8, the conviction is sustained only under lesser charges. Now the reasons for acquittal when they appeal, we've tried to categorize them. Lack of evidence is 16. These are overlapping, but important or key witnesses are not examined. The courts often comment upon in their judgments the callous and indifferent attitude of the prosecuting agency. So that is what we are hoping to rely upon when we think about criminal remedies alone. In terms of criminal justice machinery, the judiciary is one piece, and the judiciary very much echoes the very common narrative that we have in the public domain, which is of superstition, medieval mindsets, barbarism, the tribals, almost blaming them for their condition of having no health care, no formal education, no access to police for early redress. So, they are held responsible for a condition not of their own making. And in conclusion, our findings are that special laws are preemptive in nature, but they are rarely invoked. No matter how many special laws we have, police will wait until the IPC offense is committed, because that is the machinery that will respond to any special law. The higher courts show that it's only murder and killing which proceed further. It's the convict who seeks acquittal. Now, prosecutions are primarily framed under very small offenses like 323. So one of the recommendations we felt that what we don't have is blackening the face, parading, which are common idioms or common ways by which communities inflict humiliation and punish, whether it is against transgender, whether it's against women accused of adultery. There are many more cases other than witch hunting where such community humiliation is used. So in our view, these should best sit within IPC, delinked from the motive of witch hunting, because otherwise you would only have a remedy if the motive was of witch hunting, but not otherwise for the same crime. Now, the biggest justice gap to our mind relates to restorative measures to secure against future harm. Even the 5 cases from Jharkhand, the families have been quoted as saying, well, what if tomorrow they come after us? Because they are still wandering around, their families are still holding their head high, the accused. Dislocation, we found people leaving their land, their homes, their livelihoods, nobody giving them work. And so the spiral of impoverishment, and they can't live with their relatives because the relatives get threatened. So after some time they have to leave the house of the relative and move on. In the 85 FIRs, what we are saying is 80 survived, and their lives are as important, and their justice needs go beyond solutions within that the criminal justice system offers. Then there is a troubling silence amongst the activists on the structural causes and linkages of witch hunting with the underlying conditions. There has to be a governance component in this where an accountability can be pinned, because the Maharashtra and the Karnataka laws are so punitive, where they are almost punishing any kind of practice, and Karnataka proposes to make the crime regardless of consent of the two parties. So if I wear a tabiz, for instance, or do some jharphook in my house, I could be prosecuted under the Karnataka bill if it was ever enacted. We keep talking about awareness raising without talking about the structural conditions that force people to live in situations of high deprivation. And last is accountability and roles of state and non-state actors, because this is not related so much to the law as to the first part, where we found many of the victims who had to flee their homes were able to come back because of Mahila Samakhya workers. Monisha Behal is here. She was one of the partners, Northeast Networks, for the Assam study, where the Mahila Samakhya women find a way of involving these women in their work and give them a little social support for them to continue to live and not feel threatened. So we need to strengthen these kinds of actors on the ground who we know can take on these risks and confront the challenges. Thank you.